Okay, so welcome to the meeting of the Employment and Income Maintenance Subcommittee of the California Paraprofessional Program Working Group. Calling the roll, Fleischman indicated. Yeah. Shining has not yet joined us. Spyro?
Here.
Judge Yu?
Here, thank you.
Thank you.
So Linda, can you allow me to screen share?
Yes, I just had this up as a placeholder to.
Okay.
So I noticed there's some attendees. It says 2, but I only see 1. I'm not sure if we want to have any comments. I know we have only an hour, and this is really a planning meeting. So let me know if you think that that's appropriate now or at some other time during this hour.
No, I think it makes sense now. I think I didn't see these these folks when I started talking.
So now there's 3: Zach, User, and Miss McVeigh. Would any of the 3 who are here from the public wish to make any comments? If so, could you? Okay, it looks like Miss McVeigh from Betzetic.
Go ahead, you can speak now.
Hi, Miss McVeigh. Thanks so much for being here.
Hi, thank you. I'm glad to be here. I'm calling in from Betzetic. I'm part of our employment rights team, and we represent clients in wage theft cases, workplace gender discrimination, and with unemployment insurance issues. We look forward to continuing to work with this committee, and we're here to listen, learn, and provide perspective. We believe that low-income clients need adequate, free representation by trained attorneys with thorough understanding of their area of the law. With that said, if a paraprofessional program is instituted, we strongly believe that it must institute fee caps. We know that from previous studies, the Justice Gap studies and subcommittee studies in June 2020, that there are many barriers to legal services for low-income individuals in California. We worry, however, that if there is not a fee cap, that for-profit paraprofessionals could actually increase that gap. In our UI practice, we've already seen clients using tax preparers and other services for help with applications and certifications. These clients are often charged $70 plus for an application and $20 or more for biweekly certification. This is not only a burden on low-income individuals in California, but on unemployed middle-income Californians who are at a period of economic vulnerability. We also believe that any paraprofessional program would require thorough training, guidelines, licensing, and enforcement of ethical standards. As it stands, we've seen many low-income clients through our Employment Rights Project who've lost money and did not receive much needed help after seeking services of notarios and other non-lawyers. Without thoroughly structured licensing and discipline, we worry this type of practice could grow. We're happy to provide our expertise and narrative from client experiences to aid this committee. And thank you. We look forward to continuing to work with you and learning and listening throughout this process.
Ms. McVeigh, thank you so much. I noticed Carolyn is in the public attendees list. We might want to move her over. Ms. McVeigh, thank you so much for that information. And I actually think it would be helpful for us to see the statistics that you say about, for example, the UI, $70 for an application and $20 for biweekly certification. I think that we hear these things, but to actually see it and have some concrete numbers, it would really, I think, support your position and help us get a better understanding of how broadly this is experienced.
May I ask Ms. McVeigh a question?
Yes,
Sure.
I'm sorry. I think she was trying to respond to me first, though, Ira, and I did not see your hand up, so I so apologize. I would have come to you before I spoke. Ms. McVeigh, did you want to respond to what I just said, though?
Yes, I was going to say we don't have hard numbers on this statewide. We do have experience with our own individual clients, and we've had a number come through recently who are experiencing this. I would be happy to talk to more advocates who are working in the UI space, though, to get their perspective on how frequently they're seeing this, because I know, I've heard of this happening pretty frequently in the Bay Area also at this time.
That would be so helpful, because we hear these things, but without any sense of how broadly it's experienced, it's hard to understand the gravity, so that would be so helpful. Thank you. I think Ira has a question for you at this time.
Yes, Kelly, you talked about fees. maybe you need time to think about this, but how would you feel about contingency percentage fees if they were capped, if the
So
percentage or amount were capped?
I'm going to jump in and Judge, you, of course, your chair, but this is the Employment and Income Maintenance Subcommittee. And I think fee caps, contingency fees, all of that is not squarely or certainly not solely under the purview of this subcommittee, and we will be addressing it as a full working group. I just want to make sure that we have time to focus on what we need to today. So I just wanted to jump in with that, Judge, your call, but maybe we could at least be mindful of the time on topics that are not squarely related to what we're here to do today.
Thank you so much, Leah. I so appreciate you. And you're right, we only have 60 minutes. Let's have an answer, if you don't mind, Ms. McVeigh, that's as succinct as you might be able to make it, so that Ira can have his answer, and then we should move on. Thank you, Leah. It's hard to jump in, and so I appreciate that you did that. Ms. McVeigh.
Yeah, certainly. Ira, I don't have an answer off the cuff regarding contingency fees. I will say that at least for my clientele, I focus on UI issues. Honestly, any fee and not having access to free legal representation is very hard. Most of my clients, even if it were a contingency fee that came out of their UI payments, that would be a struggle for them. Many of them are receiving, $167 a week while being unemployed. So, it just, any sort of cost is a struggle, and our preference is for free legal services for these individuals.
Thanks so much, Ms. McVeigh. We look forward to hearing from you in the future. Appreciate your time this morning. Anybody else among the 4 attendees from the public who would like to say anything? If so, could you please raise your hand? Okay, looks like no. So I know this is a planning meeting, and I'm going to ask Leah if she would, or Linda, if they'd like to frame the issues for us. And Leah has her PowerPoint there.
Yeah. So I just have a few slides. I'm hoping that we can go through the action to date on both employment and income maintenance. These were 2 separate subcommittees previously, and we merged them because of the significant overlap of the issues, particularly once employment got winnowed down as it did last summer. So starting with employment, this slide just gives you the justice gap study identified employment areas of need there on the left. All of these were worked through by the employment subcommittee, and some touched on by the income maintenance subcommittee. And you can see in the right the working group decision or action that has been taken with respect to each. And basically what we get to is an employment, the only 2 remaining areas or sub areas are wage and hour claims and unemployment benefits. There's a little, I think, there's some lack of clarity around exactly what the working group did with respect to these 2. In one of the memos, it says that the next step with respect to wage and hour claims and unemployment benefits is actually to specify allowable tasks. I think it is also fair to argue that both of these are still under consideration as sub-practice areas. So I think both positions have merit. Certainly, I think that as chair, Judge, you'll have to decide where we want to go with wage and hour and unemployment. But certainly what's accurate is those are the only 2 remaining standing topics within the employment law space. If I move over to income maintenance, we had all of these areas on the left that were identified as in the justice gap study. The income maintenance subcommittee collapsed these a bit into 4 categories, and you can see the overlap with unemployment benefits here. And with respect to the action taken for the unemployment benefits, I simply repeated what was on the previous slide. For public benefits, I think it is clear that where we are is to specify the allowable tasks. Now, here we're talking about administrative agency proceedings, specifying what licensed paraprofessionals will be authorized to do vis-a-vis these proceedings. And of course, because non-attorneys are already allowed to practice in the hearings themselves, we're talking about the authorized scope outside of the hearing and all of the issues that remain outstanding as to when these cases move over into Superior Court. Steve?
Yeah, as it relates to any federal benefit, my recollection was we felt we had to exclude like Social Security just because we can't do anything federal related. Am I remembering that correctly, or?
No, you're right. I have SSI and SSDI appears excluded, but you're right. These are public state benefits. That would be more accurate.
Okay.
Yeah, not federal.
Okay.
We did exclude those. You did exclude them.
So going back one page, my recollection is the second position you said, that we spent so much time on the other issues that we simply didn't get around to wage and hour claims. And unemployment benefits, we were tied 2 to 2 because of the issue Carolyn raised, that applying for unemployment benefits can have potential consequences down the road in a wrongful termination case. And so we deadlocked on that one, and wage and hour, I don't recall that we ever got to, but my view is there are statutory fee claims for those types of claims, and that category fits in with the other categories of cases we excluded. And so to me, that's an easy one. That's just my view.
Okay, well, let me get through the slides here.
Okay.
So I wanted to actually provide the resolutions, which I think, Steve, you also shared in a quick memo that you sent out. So these are the resolutions in June and in August. Now, there is a section of the memo, I believe it is the August memo, I can pull it up, that in the next steps piece of that memo, that's where it talks about clarifying the specific allowable tasks in wage and hour and unemployment. And that's why I say there is, I think, a genuine lack of clarity about exactly what occurred, but these are the resolutions. So full scope representation. Here I added the asterisk per your note, Steve. This wasn't actually in the resolution. And we know from the minutes and the body of the discussion that the full scope representation at administrative agency level is limited to public benefit proceedings against state benefits. So what are we hoping to do today? What I'm hoping we can do is use this as a planning session to talk about these 3 remaining areas within the broad category of employment and income maintenance. What information do you all need? What kind of subject matter experts would you like to hear from? And any other necessary kind of to-dos or action steps, information we can bring forward in order to help you all reach a decision in time for submission to the full working group in April. So the decision being included, excluded, specific allowable tasks. So we get to that level of detail now that we've seen in collateral criminal and in family law.
Carolyn has her hand up.
Okay, so just as a super thing that quick, the New York State Bar is, I think we all saw, or everybody saw, that they're considering providing licensed social care workers to have some kind of additional legal benefits. And I think that would be really interesting to see the scope of what they're considering. It's something that I had thought of as it pertains to, have someone who's dealing with public benefits, housing, all kinds of things in the homeless community and the housing insecure community. So I'd really love to see what they're talking about, because that could be a real addition to someone who's a social worker who's trying to get things done, who thinks they have to call Intercity Law Center, who's too busy. Maybe that's a kind of a person that is already meeting those challenges who could need that a little extra boost.
Okay, so you'd like to learn more about what New York is considering with respect to licensing social workers.
Right.
Thanks,
All
Carol.
right.
Any other thoughts from anyone in terms of what we would like in terms of information or whom we'd like to hear from?
Yeah,
Ira?
wage and hour. Well, I know a lot about this. It was my field, but I think we ought to get people aside from me who lawyers and people in the maybe in the labor commissioner's office who can talk about number one is the extent, or if there are relatively low value wage claims where it is difficult to get lawyers to represent, despite there being a attorney's fees provision for most of those claims, not all of them. And then there's these things called Berman hearings, wage and hour hearings that are administered by the labor commissioner's office. And I'd like to hear from lawyers and maybe somebody in the labor commissioner's office about the need or lack of need for lawyers to represent, for representation of employees in those hearings. They're not represented by the labor commissioner. I thought I had something else in mind, but that's two things.
We'll come back to you, Ira. Carolyn, is that a new hand or an old hand?
Yeah, no, that's a new hand. Because
Okay.
Just to kind of bounce off what Ira was saying, we had the past president of the California Employment Lawyers Association and several board members of CELA who appeared and testified. And I think we also had, if Steve can correct me, several defense attorneys who specialized in this area. So we could have them back because, again, like I know Ira's also very experienced in this, but they're very up to speed. PAGA, Starbucks gives people, tips. You have the tip jar for Starbucks and you got, whatever, $10 a day. And that was, so that was a very small example of someone who had a very small case, but that was a massive class action that benefited people, $100 a month or something like that. So, so listening to, Jeannie Harrison or some of the other CELA board members who've monitored this might be really good to talk about those specific wage and hour hearings. And also with regard to the Berman hearings, I think I was right on that. There are lots of situations where people cannot and do not get a lawyer going down to that sort of thing. But again, that's an overlap between the very short PAGA deadlines. So I think if hearing from someone at the Labor Board Commission, I think would be excellent to talk, but also to hear from someone from CELA or the Defense Bar and Employment to kind of go over the overlapping evidentiary issues and the statute of limitations issues, because even the smallest of claims can bear fruit or impact thousands of workers. The Uber and Lyft cases, I think some of those for specific expenses that Uber does not reimburse, just again, handfuls of pennies of things that will add up to thousands of dollars for people. There's no problem getting those. So that would be my thought. If we hear from CELA, we can hear from some of the defense people that Steve brought in, hear from the labor commissioner staff, but it's a real thicket of federal and state laws, even though it seems simple.
Steve.
Yeah, we spend an inordinate amount of time on these subjects, hearing from dozens and dozens of attorneys. I am very comfortable in saying I don't want to spend any more time knowing about wage and hour in Superior Court because there's a well-established bar that handles those claims. On the other hand, as Ira points out, if we want to hear from people about administrative hearings, fine, we haven't heard from anybody for that. But, Erica, I review every Court of Appeal opinion every day, civil, published or unpublished, at least just a summary of it, the introduction. And there is so much wage and hour litigation. It's unbelievable, frankly. And they're all represented by attorneys. And, you know, we can go back and talk about what the Justice Gap Study shows or doesn't show. But as far as I'm concerned, no one's made any showing that there aren't enough lawyers to handle Superior Court actions for wage and hour claims.
Well,
I would argue the contrary exists. So, you know, I'm ready to vote today to exclude that. And if we want to talk about wage and hour and administrative hearings, fine. But I don't, you know, Jeannie Harrison was great, Carolyn, but if you want to bring her back to talk about Berman hearings, she's a dynamic speaker. She's clearly a top-notch attorney, but I don't think anyone is seriously contending there aren't enough lawyers to represent plaintiffs in wage and hour actions in Superior Court.
I am.
Hey, Ira, please wait. I put my hand up because I also wanted to get in the queue to say something. And thank you, Steve. I wanted to say, I don't think it's fruitful to bring back some of the same people we've already heard from. I kind of agree with Steve, like we've already heard from a lot of people. But Steve and I were able to meet with Judge Dora Padilla in the workers' comp situation. And hearing from a bench officer who saw these cases was actually really helpful. So for me, I felt in the past, some of the people we had really were advocating as opposed to sort of like being experts who were just kind of neutral and not taking a position. And I think it's helpful to hear from labor or excuse me, like administrative hearing officers who may not have a, I guess, an agenda, for lack of a better word, so that we can be educated and ask questions with some thought that the answer is coming from a place that's not informed by an agenda. So Ira, go ahead.
Yeah. I'm sorry that I broke in there, but
That's okay.
That it makes me angry, frankly.
I know, but we have to be dispassionate in our work. You know, we're entrusted by the appointing bodies to be clear-headed and professional. So I know it's sometimes difficult. I know because I have to do it every day on the bench. I know how hard it is, but you know, we can do it for the hours that we spend together in a limited time.
Well,
Go ahead,
I don't know that I completely agree. I mean, our positions, if we have strong feelings about them, our positions need to be informed, and there's a place for expressing them.
Yes, but we can express them without interrupting and just being in a very civil way that lawyers are required to adhere to. Go ahead.
Well, I was told that nobody seriously contends something that I contend. So that's part of what caused my reaction. But anyway, what we heard from, as far as CELA, and these are my colleagues, are people who have an obvious vested interest in not having competition. It's clear as a bell. And I know from personal experience going 20 years this year, that there are plenty of small value wage and hour cases that it's very hard, sometimes impossible to find lawyers to take. I'll find people to on that subject if you like, and I think they will not be members of officials in CELA because what I just said, although maybe they will be. But it is not true that the word was plenty of lawyers. Yeah, there's plenty of lawyers in our state, but that doesn't mean they're going to represent people with small value wage and hour cases. So I will find people to talk about whether there is a need for some of those plenty of lawyers to take on those representations by lawyers or paraprofessionals.
Thank you so much, Ira. You know, what I was thinking is each one of us can make assertions or draw conclusions based on our own perspective. But as I had mentioned to Ms. McVeigh, if we could get some data, that I think would be really helpful, so we can judge for ourselves what the scope is for some of the things that are being asserted and what the needs are. So if you have any access to data, as well as people who can talk about their own personal experiences, that would be helpful. Leah, I'm wondering if you have any questions about what else people would like, or if you have thought about what might be useful for us to hear from. Greg, if you want to jump in to Linda, Justice Petru was here. I think she might still be here. Please feel free to jump in. Brady, maybe I'll just ask Greg, did you have any thoughts? Did you want to talk about anything today with respect to this question?
Someone had mentioned, I can't remember who, it would be helpful to hear from the Labor Commissioner's office, I think. On my own personal experience, I used to do employment litigation as well, and primarily defending employers. And I would go to Berman hearings. I can't remember an attorney representing a claimant at a Berman hearing that I attended. So it'd be interesting to hear from the Labor Commissioner about what are the statistics around parties, that claimants that come into that process with an attorney or with the assistance of an attorney, to the extent they have that information.
Thanks, Greg. Justice Petru, would you like to say anything here?
I was, Brad took the words out of my mouth, so I'm good.
Okay, thanks. Brady? Oh, I think you might be muted, Brady.
The only thing that popped into my mind just on this most recent discussion is I know that we have some IOLTA recipients here at the State Bar that do plaintiff side employment work. And one of the conditions for receiving funding for that work is that they not be able to, that there not be a market for private attorneys who are going to be getting attorney's fees to serve whatever communities they're serving. So if it would be helpful, I can find out the name of one of those organizations, and you know, if we could get their perspective on which populations aren't being served by the private bar as they see it.
Okay, thanks, Brady.
So,
Linda and then Leah. Linda, do you have any thoughts that you want to share on this subject?
I don't have anything to add
Okay, thank
on
you.
what's been said. Thank you.
Sure, thank you. Leah?
I'm just really interested in this issue of the enforceability of the wage and hour judgment that an employee might get at the administrative agency side. Because I thought what we heard is that a large percentage of these judgments are not enforced, and that workers don't actually collect on the back wage that are owed. And so I had understood that there was in fact a need on the Superior Court side vis-a-vis that issue. And I just am not sure how we dig into that, because for example, I don't think we're going to get JIBS's data on the percentage of unrepresented litigants and wage and hour claims. Like, we just don't have that level of granularity in the data. So thinking, Judge Yu, about your, I think, very good emphasis on having a data-informed conversation, not an anecdotal one. I'm just thinking about how can we get at that in a way that's not purely anecdotal. And I don't have an answer, but that's my.
I'm wondering if we could ask Ruth Silvertaub, because I think she spoke to us, I think twice, but she's one of the ones who said it's difficult for people to enforce these orders. And she does so much work on this locally in our county as well as statewide. I wonder if she would have access to ways we could dig in and try to get some of the data.
You've got a couple hands up, Judge.
Oh, sorry, I don't see any of the hands up. It's not showing.
Steve and Carolyn have their hands
okay,
up.
thank you. Steve, would you like to go?
Yeah.
Thank you.
Erica, with respect to the issue you were just talking about, enforcement of unpaid judgments, we agreed, I think you and I actually, in general civil, to include that within the scope of the paraprofessional program, as long as it's under $25,000 and in limited jurisdiction. So we've already looked at that issue, and we've already addressed that issue. In other words, once a worker has a judgment, actual enforcement of it in Superior Court, limited jurisdiction, we've already agreed that will be in the program. So I actually don't want to hear anything about that, because we've already decided to include that.
Okay, Carolyn?
Oh, that also begs a question, but again, it's not for this day or time. what Steve just said, but we'll deal with that in another time when I can hopefully be involved in that subcommittee, because I was not involved in that. But
Are you not part of the civil subcommittee now?
well, it was unclear.
Oh, there's a list. I'll check it while you speak. Go ahead.
Yeah, I think I tried, but it was full, and then I sat in. Anyway, be that as it may. No, I was thinking,
You are on the
Oh.
Consumer Debt and General Subcommittee,
That's
Carol.
what I thought. Thank you, Linda. I was going to go check.
To be fair, she wasn't originally on
Right.
general.
No, but
Yes.
she is
The
now.
committee got merged.
Right, because right.
no, it occurs to me also that the Attorney General's office we may want to hear from someone from them who specializes in these cases. Again, under PAGA, the Attorney General gets a significant amount of income and money to the state as a result of the PAGA decisions. So we may need and want to have someone from the Attorney General's office weigh in. I think that would be someone we'd want to hear from and who would have a really vested interest in seeing this go into a paraprofessional realm instead of through the PAGA process.
Thanks, Carolyn. And I've changed my view, so now I can see hands. Sorry, I couldn't before. Ira, would you like to go next, and then Steve?
Hey, just two things. As far as the previous decision by the previous two-member panel on enforcement of judgments, apparently the decision was to limit it to $25,000. I think we should consider whether it ought to be that limited. And secondly, I'm not sure what Carolyn means about the PAGA, but let me say this, that for anyone who doesn't know, PAGA is the Labor Code Private Attorney General Act. And the only thing you can get in a PAGA case, collective or if they're non-collective, they're supposed to all be collective actions, is penalties. You can't get back wages. So I don't know if that pertains to our subject or not.
Okay, thanks, Ira. Steve?
Yeah, we discussed PAGA previously, and because of the representative nature of most PAGA actions, we decided, my recollection is we decided not to go there because they are pseudo class actions typically, although you can have an individual claim. And my recollection is we specifically decided not to include PAGA.
Okay, I saw
that's my
another hand go
recollection.
up, and I'm just going to insert myself by saying we're kind of going off track by trying to decide what we decided. And really, this is the planning meeting for us to figure out who else we want to hear from and what else we want to see. So let me just check in with Leah and see. It might be helpful that we're rehashing this because it's drilling down in clarity, but it might be that we're not using our time very well. So Leah, is this conversation about PAGA, which I think we all know what it means, helpful, or should we kind of get back to the larger question?
I think it is helpful in that trying to get that list together of what we need to further explore, bring back to the subcommittee. Like, is PAGA on the list or not? Do we need to dig deeper into those type of proceedings or not? So I think it is.
Okay,
that's my two.
Great.
Yeah.
Thanks. Steve, I think I then cut you off. Would you like to finish up? Anything else?
Well, no, just to point out, we started with the concept of, in general civil, it was going to be limited to limited jurisdiction court. Now Ira's saying, but I'm worried about people with really small claims. But on the other hand, he wants to make it unlimited. I mean, that seems to be contradictory. If the concern is about people with really small value claims, then the $25,000 cap makes sense.
Okay, Carolyn and then Ira.
Okay, and just, again, I don't want to rehash too much, but when I bring up PAGA, it's because it overlaps with all of what everybody's talking about. When you claim certain things in a wage and hour and you blow that statute, you may be blowing it for thousands and thousands of people. So it's a massive overlap. And when you give someone we're opening up a can of worms that brought the attention of hundreds of attorneys to this issue. And I don't think it was productive in terms of what Justice Petrao is thinking should be a pilot program. So these are much bigger things that may have merit, but I think Steve Hamilton was saying it before, as a practical matter, is this something we really want to spend the working groups limited time on? Anything that relates to wage and hour that isn't administrative. And I think you'll find if this is something that we're going to reopen and rediscuss again, we will be spending hours and hours and hours and hours and hours, and we will incur thousands of public comments on something that may not be worthy of our consideration and may be very confusing in terms of dozens of California laws. I think, again, Justice Petrou wanted people to kind of dig in. What laws are we going to need to change and impact in order to get this program going? If you get into wage and hour, the list will become 30 pages.
Just prerogative of the chair. When we
I'm
talked
done.
about this, I was persuaded by what Carolyn and Steve were saying that PAGA shouldn't be part of this. And so Ira, I know you weren't able to come to one of the meetings, and that might have been the one that you missed, but please go ahead, Ira, you're next.
No, I agree with Carolyn and Steve that we don't need to discuss PAGA.
Okay.
And I also wanted to say that Steve said something about me. Well, here, I'm not in favor of unlimited,
Right, you're
no
not.
limit on the cases that paraprofessionals could do, but I do think that $25,000 might not be the right cutoff. It might, it's possibly, it should be higher.
So just to also prerogative of the chair, I was one of the people that did agree to that, and it could have also been at a meeting you weren't able to attend, and I'm sorry about that, Ira. But my view is that I think paraprofessionals should be able to do the full-on representation on the cases they have, including following the case and going into Superior Court. And that's the paragraph that I wrote or contributed to the reports that we generated. And so for me, I thought if we're starting off, it's better to start off with limited jurisdiction cases than going, all the way up to a much higher level. So that's why I voted there. And I think we shouldn't have to go back to some of the decisions that were made. I'm a little bit disappointed that I won't be at the March 26th meeting so I can vote on in-court representation, but that's the rules we have. We can't, if we're not present, we can't vote. So I don't think we should go backwards. Steve, did you want to say anything new that you haven't said so far?
Yeah, I'd like to make a motion to exclude all PAGA claims from the program. And I invite a second.
I think that we are not there yet. And right now this is our planning meeting. And so I think Leah's hearing us, all four of us said PAGA's not in, so she's not gonna have to find someone for us to hear about from PAGA. I'm not sure we should be voting at this point because it was meant to be a planning meeting, but if it's helpful to staff, do you wanna vote on that issue, Leah?
That's totally up to you.
Okay.
I've certainly have noted that we're not going to discuss it any further. So
Steve, all four of us kind of agree on that. You're just trying to memorialize it though and lock it down, right?
Yes, there's Erica, there's a method to my madness.
Okay, tell me.
Okay, the method to my madness is if we explicitly say we are excluding PAGA, that will avoid hundreds of attorneys wanting to show up to say at the next meeting, don't include PAGA. Okay, so I'm trying to move things forward in my own way. And the only way I know how to do that is to make motions to try to cut things down. And what I'm hearing is either unanimity or near unanimity that PAGA doesn't belong in this program. So that's my motivation. I have no ulterior motive other than trying to move things forward and eliminate controversy. If we send the message that PAGA is in play, we are going to be filibustered with public comments from here to eternity.
Okay,
So,
I appreciate you making that clear for me, and I really appreciate that. So Carolyn, your hand is up. Are you the second?
I will second with the caveat, maybe a friendly amendment that could be rejected. PAGA is just one component of a wage and hour issue when it comes to civil actions and civil complaints. So you can say you're excluding PAGA, but it will come if to the extent that we're considering in this subcommittee or in general civil, anything that has to do with employment, related wage and hour claims on the civil side, that same group on all sides will come in and chime in and want to have a voice. So just saying we're not going to consider PAGA is not the point. It is an element that will be impacted because people will blow that statute, won't consider it. So the small wage and hour claim that would be taken is still impacted. It's still going to be implied. We can exclude that, and that's fine, and that's safe, and that's helpful.
Okay, you're repeating and we're running out of time. So thank you so much, Carolyn. Steve, anything you haven't said yet?
Just that I would happily accept that amendment to get this process going.
What's the amendment?
I'm sorry, I lost track of exactly what the amendment was.
I think we should, Carolyn is saying that whether we do this or not, it's still gonna be we're still gonna hear from people. So I'm gonna say no voting today. Let's just have this be our planning meeting. I was gonna ask Ira if he wanted to vote, but I think we're losing time on something that we should be dealing with later. Anything else that we want in terms of investigation or data or information as we move forward? I'm gonna go run more round. Greg, anything else you want to add?
No, I don't. I have nothing to add. Thank you, Judge.
Sure. Justice Petro, anything else?
No, nothing else from me.
Brady? Linda?
Nope, thank you.
Okay, I'm going to go to you last, Leah. So I cannot remember if it's Steve hand that went up or Carolyn. So I'm just going to go to Carolyn first and then Steve.
Okay, yeah, I think the focus of this subgroup should be on the public benefit side. So I would like to hear from more of the public service folks. I think, we have Ms. McVeigh and I think Stephanie Carroll from, I think it was public service. Also, no, we haven't heard from anyone from National Neighborhood Legal Council. So, or even intercity law. I think I would like to focus our time on the public benefit side of this, including the New York proposals. So that's where I think we should spend our time.
Thank you, Carolyn. Steve?
I would ask staff to look into whatever data is available about so-called small value wage and hour claims and whether or not there's actually a need for additional providers of legal services in that area. Because even the absence of data, to me, would tend to suggest that there really isn't a need. And I suppose part of that is Judicial Council statistics on how many unrepresented parties are there in these types of cases, if that data is available.
Okay, thank you, Steve. Ira?
Well, I just want to say this, that it seems impossible there could be data on most of the cases, wage and hour cases that are not taken by attorneys because they're not filed, they're not pursued.
Yeah, it's a challenge for staff. They did an extraordinary job, I think, in the pilot subcommittee, and they're still trying to get data. And I think part of why that pilot subcommittee was able to get to decisions that there was consensus around was that it was so helpful to have the data. This is a difficult slice to cut to get the data, but I know staff will try their best. And for me, I'm hearing a lot of anecdotal stories as well as some very passionate arguments. But for me, I think data is going to be really important. So that's all I would add. Leah, do you have any thoughts? And is there anything else you'd like us to accomplish in the 15 minutes that we have left, or 14 minutes?
No, I do want to talk about kind of how we would hope to sequence things and then as informed by the realities of trying to actually get information and people to come to the table. The only other thing I was going to add is another issue that came up, and maybe this was in our conversation with Ruth, is the fact that in these administrative agency proceedings, you already have a whole host of non-attorney actors, non-attorneys representing parties, including kind of advocacy organizations that are often aligned, some aligned with the plaintiffs along like race or ethnicity lines. Like she talked about, like the Filipino Workers Association, I think labor unions have non-attorneys who support people in pursuing these claims. And Ruth, I believe, expressed some concern that in creating parameters around what is an authorized scope of practice for a non-lawyer, we may inadvertently and in an unintended way have a negative impact on these folks who are already doing work in this space. So like, we don't want to do something that then precludes people who are already serving particular communities effectively from continuing to do what they're doing. So something around us understanding who the folks are, who these organizations are, and a kind of do no harm model, I think would be important.
Oh, I agree. Thank you so much for remembering that and thinking about that. So if Ruth is among those that you're going to just interview to see if there is data, it'd be good if she could help us there. And maybe we do have Ruth come back.
Okay.
Okay.
So in terms of
go ahead.
Sequencing, yeah, Carolyn, I know it sounded like you were really hoping maybe to focus on public benefits. We do, I think, need to take things somewhat in an order and try to line up both the data and the subject matter experts for particular meetings based, again, on some kind of sequence. So public benefits is distinct from I don't know, they all have this overlap of having an administrative agency component, hearing component, all three of these that we see here. So just, I'd love to hear from the group. What would your thought be as to which to start with?
Steve had his hand up first.
Yeah, Erica, if I recall, there is a judge in your court whose first name is Socrates. Am I remembering that correctly?
Anukian.
Yes. I would like to hear from him on the issue I'm talking about. Like, does the creation of statutory fees in his actual experience in his courtroom provide access to plaintiffs? I understand he has views on that, and I'd like to hear those views. I don't know if you're friends with him, if that could be arranged or not, but I'd like to hear from him.
Then I'm not sure he's been in civil for a long time. I don't know what his current assignment is, but I would not think of him as an expert in the field, despite the fact that he has a lot of knowledge about a lot of things.
He has to. He's named Socrates.
I know. He really does.
That's a tough
Justice
name to
Petru
look
and I
into.
both know him, and he's not someone I would think of as an expert, and I'd hate to have us spend time on, our staff spend time on things that isn't so fruitful. So I'm not sure if this is possible, but I'm wondering, Leah, could Steve just have a conversation with Pete Manukian to sort of figure out for us the depth of knowledge there to see if it's worthwhile to hear from him, and it would satisfy Steve wanting to hear from Pete? Or do you think we shouldn't go out and do our own independent investigation?
Well, I think if we did it, I would like to just participate, just as so that it can be
Yeah, that's a good idea.
assessed for the subcommittee. I think that's fine.
Okay, so maybe a side conversation can be set up with Pete Manukian to see if he, if that would be good. I just don't. He's not thought of as an expert in this area.
I take your word for it, Erica. All I can tell you is I have personally 2 appeals from his orders on attorney fee motions. And when you think about the small number of cases that go up on appeal, that struck me as perhaps a coincidence, but perhaps not.
Okay, thank you, Steve. Carolyn?
I think there may be some people that we could get from the bigger counties that have homelessness courts. I know Los Angeles County has had, and in the past, kind of actually a thing called homeless court, where tickets are removed and all kinds of things are done. Also, the people who run and are operate, yeah. So that's something I think we could look into, is Los Angeles County's homelessness. The Los Angeles County LAHSA Homelessness Authority may be able to provide us with some examples of people who are working in the homeless community who could use that additional boost. So I would like to see if we could look there.
The homeless courts, like our county has as well, they are generally dealing with helping people clear out infractions, like evading fares, and you said, public intoxication and traffic tickets. I'm not sure if they do any work in terms of unemployment or wage and hour, because the superior courts that have those are really trying to help people clear out warrants. But we could look, maybe just dig in and see if there's any courts that are doing wage and hour or public benefits. But I would find, I haven't heard that. And I have a lot of homeless people in my court, and I've done the stand down that Judge Hyde started, where everybody goes out in a tent and all the various counties have their homeless court all at the same time. And somebody goes and gets their hair cut, and then they get a meal, and then they come here, and I tell them to do 5 AA meetings, and then they come back, and I can get rid of all their traffic and fare evasion cases. It's all really more about clearing people's warrants. But we could take a look and see, maybe there's something out there. Any other thoughts about sequencing?
Yeah, I haven't heard much on sequencing. It sounds from Steve that you're suggesting starting with wage and hour. It sounds like.
Yes.
Okay.
I mean, to me, that's the 800-pound gorilla. In my mind, the others are easy yeses. Well, except maybe unemployment.
For me, Leah, I was thinking we should just do it where you can clump the people in their schedules and when the data comes in. So when you're ready to do one topic as opposed to the other, whatever sequence I think should be done, because it's a short time window if we're supposed to have something ready for the April 19th meeting.
Yeah. Okay. All right.
Anybody else want to say anything or any burning issues? We have 6 minutes left. Yes, Steve.
Did I hear Justice Petro at the last meeting ask for us to get lists of statutes that need to be amended to Greg?
I couldn't stay the whole meeting, so I'm not sure if that was stated. Justice Petro?
I don't recall clearly as I sit here right now. I mean, I certainly think that as we assess areas, that's something to be considered. Greg's on here, right?
Yeah, and I remember hearing Greg say.
Okay, maybe I got that wrong.
I think I misspoke. I think it was Greg who was requesting that.
Yeah, so the context of that request is pretty important. We were talking about the unlawful practice of law by paraprofessionals. There was some commentary that even if we were to stand up this program through rulemaking and perhaps some statutory changes, that we still may run afoul of several statutes in this state and perhaps even constitutional amendments. I think, Stephen, you brought that up. And so what my request was, specifically looking at the statutory provision in the State Bar Act prohibiting the unlawful practice of law, the text of the statute itself does not seem to me to provide any impediment to paraprofessionals, as long as they're licensees of the State Bar, which is what I believe we're contemplating here, any impediment in that statute. But what I was requesting, and this has come up in conversations with Stephen Hamilton. So for instance, we're talking about paraprofessionals practicing in family court. And he has mentioned at times there are specific provisions in the family code that may need to be amended that only allow attorneys to do certain things that we're contemplating paraprofessionals needing to do. And so I think it would be helpful for this entire group to start wrapping your arms around what statutes currently exist that may provide some barrier to paraprofessionals practicing in the areas that we're contemplating.
Because I have a whole list of things, some of which are pretty substantive and will require, in my opinion, discussion, like the attorney-client privilege, which by statute only extends to communications between a lawyer and a client. Paraprofessionals won't be lawyers under the evidence code. We need to have a discussion about that because we're creating a hybrid where paraprofessionals can't practice in certain areas, so they can't give legal advice. So if we're going to extend the privilege, it has to be limited to subject matter areas they're entitled to? Are we going to extend the statute of limitations for claims against attorneys to paraprofessionals? Is section 473 going to apply to paraprofessionals? I mean, those are
What I'm talking about, Steve. This is exactly what we need. We need to
Okay.
start tackling these substantive issues.
Can I send you my working list with the understanding it's not formal or anything? And can I do that without running afoul of Bagley Keene?
Well, I think as a group, we need to start assembling this list because I think it needs to be almost an appendix to the final report. Recommendations to the board, you know, if we're going to actually create this new licensed profession and it's contemplating they're going to be engaging in the practice of law, essentially the practice of law in these different areas, these are the statutes that we've identified that need to be amended in some way to permit that to happen. So I don't know if it helps for you to just send it to me. What I'm doing is trying to provide guidance to the group to start thinking about that so it's included in your final report.
Steve and Greg, Justice Petru is listening. So she now knows that this is an issue, and Steve, you are working on a list. Let's let her offline decide how that should bubble up to the group and what form it should take. Okay, but thank you. Thank you.
And I will say that some of these issues we have been discussing as kind of a staff team, like attorney-client privilege, as we are working through the development of a proposed set of rules of professional conduct. So I do think there are some of these issues that have been vetted and addressed. So I just want to allay any concerns that none of that.
The weeds on that. What we've been discussing with the rules of professional conduct is the duty of confidentiality, which was originally created by statute in 1848 in California, which makes California unique. What Steve is referring to is the evidentiary privilege. That's a whole different ball of wax.
Right, but that was identified. Some of those issues have been identified in the work that OPC has done. That's all I'm saying.
Yeah, that one's in front of us. We know about that, but there's a lot of other subtle, more subtle issues, especially in these particular areas of law that we need to start ferreting out some of these statutes and start identifying them, and then doing the analysis as to whether or not they do in fact create an impediment. And what precipitated that comment from me was I am not reading the UPL statute as providing an obstacle to this program standing up, but somebody else in the group seemed to think it did. And so what I'm encouraging this group to do is the analysis, because that's what the court will need, that's what the legislature will need in order to take action on whatever set of recommendations comes out of this group.
And I think Justice Petru can put together the plan to coordinate and have all this be as comprehensive as it needs to be. We are at 11 o'clock. I saw some hands go up and down. Does anybody need to say anything other than Leah and Linda helping us figure out when we're going to be meeting again? If I guess a doodle poll will go out.
No, I think we have meetings set.
Oh, okay.
So, yeah.
Okay, great. All right. Sorry to shove us in within a 1 hour time frame. Thank you so much for your time. Yeah, and you take good care. It's good to see you again. It's good to be like in the mix with you guys again. Take care, everybody. Have a good rest of the day. Bye.
Bye.